Okay, we'll go on record in People versus Devin Charles Letson. This is file number 255389. If I can have counsel for your opinions.
Sierra Coke on behalf of the people.
Good morning, Your Honor. Tyler Beal, P75702 on behalf of Devin Letson.
We're set for a final status conference in this case today. Mr. Beal, how did you want to proceed?
Yes, Your Honor. So I have had discussions with the prosecutor, and we've worked out a resolution of pleading to causing a disturbance.
Okay. And what is the maximum penalty for that charge?
Your Honor, it is a 90-day, 500. It's called disorderly person jostling. The PAC code is 750.1671L.
90-day,
It is.
$500 fine.
Yep.
Okay, Mr. Letson, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, Your Honor.
Okay, is that how you wanted to proceed today?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand. Mr. Letson, are you currently on any kind of probation or parole?
I am not.
You understand that by pleading guilty to this added count 2, which is disorderly conduct, that the maximum possible penalty you could face would be up to 90 days in jail and or a $500 fine.
I do, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you want it. You understand all those rights.
I do, Your Honor.
You understand that you're giving up and waiving all those rights, including the right to have a trial.
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty today?
No, Your Honor.
Has anybody promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
This happened on January 10th of 2025. Is that okay?
Correct.
On that day, were you at a location here within Crawford County?
Correct.
And did you have, well, tell me what happened on that day that would make you guilty of disorderly conduct.
Your Honor, my wife and I got in an argument. We've been together for 12 years, so I call her my wife. We got in an argument. We were kind of just following each other around the house. She called 911 on me. I still continued to just kind of walk around because our house ain't that big. We just walked around inside, outside, waited for 911 to get there. We had bumped into each other a couple of times because the house ain't that big, and I consider that the crime.
Okay. That sounds just like, that doesn't sound like a crime to me.
I know, because honest to God, that's why I was taking it this far, because this really didn't happen. I followed each other. We followed each other around the house.
Can I go out here, my client, Your Honor? So were you arguing loudly with your wife?
Yes.
And you were both inside and outside of the house?
Correct.
would people from the street have been able to hear you arguing while you were outside?
Correct.
Okay, and you also, while you were arguing, were you or her possibly, or not possibly, but while you were arguing, were you next to each other?
We were.
And so you mentioned that you were jostling, bumping into each other as you were arguing. Is that true?
Correct.
But did you ever intentionally strike her?
No.
Did you ever intentionally push her?
I did not.
Okay, thank you.
Okay, Mrs. Koch, are you satisfied with the factual basis?
Yeah, I think it meets the elements, Your Honor.
Okay. All right, Ms. Koch, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor, thank you.
No, Your Honor.
Also, are both of you satisfied that the court has complied with statute?
Yes, Your Honor.
Defense is satisfied, Your
Mr. Letson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this added count 2. The court will accept your guilty plea. We'll set this matter for sentencing at a later date. Mr. Haven or Mr. McDowell, I would just like a brief PSI, just kind of outlining the circumstances here so that I have a better understanding of kind of what happened. We'll have that prepared. And then Mr. Letson, just make sure you stay in touch with Mr. Beal prior to that hearing and have an opportunity to go through that report with him. And before you leave today, just meet with the probation officer to set that up, okay? Ms. Koch, anything further to address today?
No, thank you for taking us this morning and taking the vote.
Nothing back to the defense. Thank you, Your Honor.
So in light of the plea, the court will also adjourn. The trial date is currently set for next Monday. And feel free to go.
Thank you, Your Honor. Have a great day.
Thank you very
Thanks.
much.
Thank you, sir.
We wanted to leave a second in order for me to do. You said that was okay. Are you sure you want to go today and do the second?
Mr. Thompson, are you ready on Mr. Clark's case?
Let me.
He's gonna be my suit.
let me check.
That's a probation violation, or anything, Your Honor.
Yes. Can you,
I can be here, I haven't spoken to him.
do you want a chance to do that before we do the arraignment?
Yeah, I could try to get the jail on Zoom.
Ms. Doe, if you'd like to come forward with your client, please.
Your Honor.
We'll go on the record in People versus Shelby Sunday, file number 255436.
Sierra Coke on behalf of the people.
Jody Doak on behalf of the defendant, Shelby Sunday, is here with me.
This is set for a status conference in this file today. Ms. Doe, can you tell me where things stand on your side?
Yes, Your Honor. My client was set to do a substance abuse evaluation on September
It was on the 15th.
originally. She ran short funds. She rescheduled it to yesterday. She has the receipt that she did attend and paid for it. I did let the prosecutor know that when I found that out yesterday. But she has the receipt in the car, and she also did send me a copy via text of the receipt, so I have the receipt. She has been in contact with the Sheboygan sobriety court. They are all positive about her coming in and attending that sobriety court. In order to do that sobriety court, she would have to enter a plea to a second offense here. And they have to have that substance abuse evaluation completed in order for them to do that. I understand we're a long ways out in the case. It started, Your Honor, with the case being arraigned on the day during the ice storm, and then a warrant being issued for my client's arrest, and then us coming in and explaining to Judge Burmeister that neither of us could communicate with each other, and that I had been retained right in the middle of the ice storm, and I didn't know that there was an arraignment. And so then that warrant was set aside. Her money was actually returned to her because of the circumstances. And so the case has been proceeding for longer than would be normal, I think, under normal circumstances. And then my client has caused a bit of a delay here with canceling substance abuse evaluation and rescheduling. But she does struggle financially with some things and is doing her best. She has a child, pays child support. Is making a good faith effort here to get into sobriety court and address her alcohol issue.
I did speak to the Sheboygan County prosecutor. I confirmed that she'd have to plead to a second. I don't know when she'll know if she's going to get in, but since she's done the substance abuse evaluation, we'd ask for a 30-day adjournment. We don't object to that, and that to be the final cutoff so that we can either get this case set for trial or into a plea. She will have to plea to the second, which I will give her if she gets into it. But she doesn't know whether she's into it yet because she just did the assessment.
Okay. All right. So we'll adjourn for 30 days. This Sunday, I mean, I saw we had a stipulation back in August to adjourn this so that you can get around this variety of details. So that's been 3 months now. So we're not going to delay any further than the next 30 days. So whatever you need to do over that period of time.
So now it's just waiting. It was yesterday, the lady that did my assessment said it would take up to 10 days and then it'll be sent to Jody and also the court.
Yeah, okay. Yeah, I'm just saying, they call you back and say X, Y, or Z. Back here 30 days. And the issue is something for them that they needed.
Okay.
So,
You have to plead to the third offense and you're not get sobriety court.
I'm aware, yes, and I believe that everything's set in stone with my assessment.
You'd have to plead or you can go to trial. I'm not saying that it's his trial. You'd have to plead at third, you have to go to trial. Thank you for your grace, your honor, and for your adjournment.
so we'll send you a notice of the date and time of that hearing, make sure that you say.
Okay. All right, thank you.
Thank you, your honor. Thank you, Sarah.
I wasn't able to speak, Mr. Clark, so you already set up on this system.
Let's just a little go. Sure. Mr. Clock, are you able to hear me okay?
Yes.
All right, we're on the record now in people versus. Clock, this is file number 255442. The record should reflect that Mr. Clock is present today by video from the Crawford County Jail. Mr. Clock, you're before the court today for arraignment on a number of different probation violations. Have you been given a copy of the warrant explaining those violations?
No.
Okay. Have you been told what the alleged violations are?
Yes.
Okay. So I need to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You have the right to have an attorney present at any subsequent proceedings. You have Mr. Thompson present here today for purposes of this arraignment. And if you wanted to or needed to speak with Mr. Thompson, I would take a break from this hearing and allow you the opportunity to do that. Do you understand that?
Yes.
If you are found guilty of any of the non-technical probation violations, it could subject you to the maximum possible penalty on your underlying charge, which is up to 2 years. Do you understand that?
Yes.
Did you want to request a court-appointed attorney, or did you want to speak with Mr. Thompson before we proceed further today?
Yes. Mr. Thompson,
right.
please.
If I could jump in, he has been arraigned on the new underlying charges. I have been appointed as his attorney in that. I think to respect his rights in the underlying charges, be appropriate to enter a not guilty plea at this time.
Okay.
And ask for my appointment as to this probation violation.
Okay, so, Mr. Clock, the court is gonna approve your, request for a court-appointed attorney. It sounds like Mr. Thompson will be appointed to represent you here as well. He's recommending that you plead not guilty to these alleged violations. Do you have any, objection to that?
No.
Okay, so the court will enter a not guilty plea on Mr. Clock's behalf with regard to all of the alleged violations in this case. In terms of, and then Mr. Thompson, given that there's underlying charges, did you want to waive the court today?
Yes,
Okay, so the court will set this for a hearing at a later date, I think 60, 90 days out.
I think that's appropriate. I suspect this will get worked out, but.
Mr. Haven, do you have any objection to that?
No objection, Your Honor.
Okay, so we'll set this for a probation violation hearing. We'll set it for 60 days out. In terms of bond pending that hearing, Mr. Haven.
Well, Your Honor, these are pretty serious charges. Happened in the jail. So I think a higher bond would be appropriate.
Thank you, Mr. Thompson.
Thank you, Your Honor. I think if there's a cash bond, I don't know that the amount really matters. Mr. Clock was awarded this fee when the events that led to his incarceration began, so he's never essentially had an opportunity to acquire property or assets, so I don't foresee him being able to postpone.
All right. Given the nature of the alleged violations in this case and his underlying charge, which involved assaulted conduct, the court will set bond in the amount of $10,000 cash or surety. The conditions of bond will be all standard terms and conditions and all conditions of probation. And again, we'll set this for hearing in 60 days. Mr. Haven, anything further we need to address on this file today?
No, thank you, Your Honor.
Nothing for the today's court record. Thank you, Your Honor.
Mr. Clock, did you have any questions at all?
No, Your Honor.
All right, thank you. That's all for this hearing today. The court's going to disconnect at this time. Okay, Mr. Doran?
He is, he's in the lobby. He'd be prepared to go earlier. Anthony, take your hands out.
We'll go on the record in People versus Anthony Doring. We have two files, file number 2355226 and 255475. The record should reflect Mr. Doring's presence here in the courtroom today. If I could have counsel with your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson, attorney for defendant Anthony Doring. Your Honor, we're here on the alleged private probation violation is the new file. We ran a contested preliminary examination. The matter was found up to Your Honor. Mr. Doring, as far as indicated, he wants to elect to pursue his right to trial in the new case. So we would ask that the court set off the probation violation to allow that to occur. It may be appropriate to have a final status conference, but at this point, we're looking at a trial here.
All right. Mr. Doring, is that how you wanted to proceed? Yes, Your Honor. Okay. Ms. Coke, how many days of trial do you think we would need in this case?
I think we can do it in one.
I think that's likely accurate, Your Honor. We have, two individuals in the home. Okay, but there's a third individual I don't believe will be called as a witness.
Okay. And Ms. Coke, can you be ready in 60 to 90 days?
We can.
Mr. Thompson.
I agree.
Okay. So we'll set it for a one-day jury trial at about 60 to 90 days out. The court will set it for a final status conference on that motion day, just prior to the trial date. Ms. Coke, are you anticipating any kind of pre-trial motion?
I need to look at his prior domestic violence to see whether or not it would be admissible, but other than that, no.
Yeah, can we just put a time in there, council, and to file a 609 or 404B type notice about prior acts, you know, that may well require a motion hearing before your honor. Just like to have that fleshed out.
So can you provide that within the next 30 days?
Yes.
Okay. Mr. Thompson, are you anticipating anything?
No, your honor, just again, if we're gonna get into that issue, I would not be surprised if I don't have any motion. I intend to file.
Okay, so I'm just gonna write in here that the prosecution to provide any notices regarding intent to admit prior bad acts evidence for the next 30 days. So that's, I don't know. Yeah. set it for-
Yes, I think there's a problem. Yeah.
So any other scheduling issues on the last review? Thompson?
No issues, thank you.
Okay, so then we'll send out notices, Mr. Doring, of your trial date as well as the date of the final status conference. It's important that you stay in touch with Mr. Thompson between now and then.
As you know.
And then the court will adjourn the probation violation without date pending the jury trial file.
Thank you.
Oh, never mind.
All right. Our next hearing, so we'll be in recess. versus Aaron Barkley. File number 255463.
To the podium, Aaron, and then just keep your hands on you.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Aaron Barkley. Your Honor, if I could approach, we have a proposed plea offer in this matter.
Okay.
Mr. Barkley would plead guilty to count 1, which is possession of methamphetamine as a 10-year felony. The enhanced dispute can be dismissed, and the prosecutor has indicated she doesn't have any objection. 7411, Mr. Barkley is eligible, so it's not a condition of the plea, but she will not object if he is eligible.
Ms. Koch, is that correct?
It is.
Okay. Mr. Barkley, have you had an adequate opportunity to speak to your lawyer about this?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, about the truth, so help you God. Barkley, are you currently on any kind of probation or parole?
Yes, I am.
Where's that?
Grand Traverse County.
Are they aware that you're entering this plea today?
Yes,
Do you know whether you're going to face additional penalties there for violating probation?
it would be a probation violation, yes.
And then you understand that the maximum possible penalty you can face for this charge of possession of methamphetamine is up to 10 years and or a $15,000 fine. With all of those things in mind, what is your plea to that charge? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial or to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. You have the right to testify at trial yourself if you want. All those rights. So you understand giving up, waiving all of those rights that you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here in court today?
no.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty to this charge because you are actually guilty of this charge?
Yes,
This happened back on April 5th of 2025. Is that the correct date?
yes,
On that date, were you present here in Crawford?
yes, I was.
And you were here in Crawford County. Did you have possession of some methamphetamine?
Yes, I did.
Did you know that that's what that was?
Yes,
Did you have any legal right to have any amount of it at that time?
No.
Ms. Coker, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Thompson?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
And are you both satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
I am.
Mr. Barkley, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Thompson so that you're prepared to go forward on that day. Before you leave today, you're going to meet with the probation officer for a pre-sentence report. Do you have any questions? Okay, thank you. Versus Brinker, case number 255411.
Sierra Coke on behalf of the people.
Drinker?
All right, Mr. Brinker is present today. Mr. Brinker, are you representing yourself
Correct.
today? Okay. All right, and Mr. Brinker, I need to do this every hearing. I'm sure you're aware of that. But
Yes, sir.
I need to make sure, number one, that you understand that you have the right to have an attorney and that if you couldn't afford one, one will be appointed for you.
Yes, sir.
Okay. And you understand the risks of proceeding on your own without an attorney.
Yes, Your Honor.
Despite those risks, is it your desire to continue to they represent yourself.
Yes, Your Honor.
How did you want to proceed with your case?
Your Honor, last week I was arrested on a bench warrant that you rescinded. And the Crawford County didn't know about it, I guess, or something, and they came to my house at 9 o'clock at night, arrested me, took me to jail, and then let me go at 5 in the morning, but my mother went up there with all my paperwork, my file for this case, to show them, like, look, the judge rescinded this, you guys are wrong, you know? And unbeknownst to me, my file for this case is still in her car, but I still like to proceed and everything like that, but I didn't know shit. She brought all of my stuff up there to show the jailers that, look, that you rescinded the warrant, but they arrested me anyways. But I was released at 5 in the morning and had to walk home, but I wanted you to know that. And getting the records that I was trying to get, I underestimated, like, they call it HIM, it's Health Information Management. And they advised me that I had to be there to have a copy of my ID and then sign a certified packet for assembly of consults, microbiology lab, and imaging that it takes. So, like I said, I thought I could just have the facts, just sign something and send it over and be done with it. But they said it's in Traverse City and I don't have a license. And they said I'd have to be there just physically sign in for my documentation according to HIPAA. So I'm in the midst of doing that as well. Getting over to Traverse and getting my stuff, but I'm here because I'm requesting I had to be here. So I was completely caught off guard with my mother having my stuff in her car because of the fact I was arrested for no reason. So I apologize.
Okay. Well, we have a trial date set in your case. That's going to occur on December 8th.
Yes.
Okay. So are you ready to proceed on your date?
Yes.
Okay, so Mr. Brinker, it sounds like we're going to proceed to trial. Is that how we're going to go forward?
Yeah.
I mean, the only other option would be a plea agreement.
Yeah.
You don't wish to do that.
I just want to make sure I really wanted to get my records and stuff, but yeah.
Which records are you talking?
There's assembly consults. There's a doctor that seen me over there. I was there for 44 days after this episode here happened, and his testimony would be really helpful or to draft a motion I'm trying to do.
Okay, but that's that stuff that the
stuff.
prosecutor has that you're.
No, not at all. As soon as I get it, obviously I'll give it to her. For purposes.
We're gonna proceed with trial. Thompson, you've already been appointed as standby, is that correct?
I am standby right now. That's my steps.
So I'll just request that you do whatever you can to be prepared for that trial date, being able to step in, assist Mr. Brinker, besides that anything you'd like to have that. Aside from that, Mr. Brinker, do you have any other questions?
No, sir. Just if I do be able to get my stuff back from my mother, because she's at $1812, and she'll be back like in a couple of days. If I get my stuff back from her, is I still file stuff?
I think we have.
She left yesterday for $1812 meeting down in Grand Rapids.
It's like motion cutoff is the final status conference, which is going to be December 4th.
Okay.
So we would need to get everything filed and set for hearing no later than that date.
Yes, sir.
Okay.
Thank you.
Ms. Koch, anything further?
I'm guessing we're gonna have to do some maybe motion on days. I'm not really sure. Mr. Brinker gave me a witness and exhibit list, and a lot of it is about character evidence and things that in his medical stuff that happened afterwards, none of which I think is going to be relevant or admissible under the court rule. So I think we may have some issues to address before the trial. But I'll look at whatever records Mr. Brinker provides, and obviously we have a couple of months to prepare.
Okay, all right, thank you. That's all for today. Ready with Mr. Van Wormer's case?
Yes, thank you.
People versus Rodney Van Wormer, file number 255465.
Sierra Coke on behalf of the people.
Thank you, Honor. Jason Thompson, on behalf of the defendant, Ryan Van Wormer.
Record should reflect Mr. Van Wormer is present here in the courtroom today. This is the date and time set for the sentencing hearing. Mr. Van Wormer, did you have an opportunity to go through the present report and talk to Mr. Thompson about that?
Yes, Your Honor.
Mr. Thompson, are there any conditions to each of this?
No,
Are there any challenges to the scoring guidelines?
no, Your Honor.
Scope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the score?
No.
Anything on behalf of the people for Alex?
Your Honor, it's, Mr. Van Wormer's 42 years old. His PRVs, I mean, they max out on our scale at 75 and his are 120. This is a very impressive criminal record that he has racked up here with 8 felonies and 16 misdemeanors and a juvenile record. His guidelines are high because frankly, he's earned high guidelines at this point. At 19 to 38, I think the recommendation is appropriate for 2 years with 45 days credit. Thank you.
Thank you, Your Honor. We do agree with the 45 days credit. I think this is a situation where, as it says throughout the PSI, I mean, Mr. Van Wormer has been struggling with addiction. He has a family background that probably predisposes him in that way, and he's been fighting that battle. So it's a situation where he, has caused danger and harm to himself because of his controlled substance use. But this isn't an individual who's a malicious individual who's looking to harm other people. He would like to get clean and sober. He was trying to pursue rehab before this event came in. He almost immediately took full responsibility, Your Honor. This is not someone who's prevaricating the court. This is not someone who's trying to minimize what happened. He's been very straightforward in all our dealings and in all his dealings with the court. So I think he's fundamentally an honest person. He agrees with the scoring, Your Honor. His request to me was he is not only taking full responsibility for what occurred in the past, he is looking forward to the future. He's trying to plan out his life. He is very hopeful to return to his roofing job when he's employed. He's a very good employee. He's very hardworking. He has, dreams and aspirations. He wants to get back to that roofing job in the most convenient time, and the best way for him to start on a good foot when he is released would be if it was near the start of that season. So we'd ask the court to consider 21 months. That would get him out, late May, I believe, of 27. And so he could hopefully start working and get through that summer, Your Honor. That's when he finds he does best, when he is working full time, when he is working hard at that demanding job as a roofer. And so that's what he's looking forward to in the future as he's coming up with his sobriety plan, as he's coming up with how he's going to do better next time. And he is committed to doing that, Your Honor. So that would be our request. The court consider 21 months on this. Thank you.
Mr. Van Wormer, was there anything you wanted to say?
I think he summed it up, Your Honor. I did act like guilty of my arraignment. I take full responsibility. Like the prosecutor said, I'm 42. Frankly, I'm tired. I'm tired of doing all this.
I did read through the report. I'm familiar with the events that brings you before the court today. Of course, there's a lot of information in there about your background, your circumstances, your past history, which as you know is extensive and results in high guidelines regardless of the severity of the offense at this point. So I think there's a number of factors here. Certainly everything that Mr. Thompson mentioned are mitigating factors. The nature of the crime here is the most serious drug offense. Selling, distributing, this appears to have been personal use amounts. So the severity of the offense is at the low end of the spectrum. course, your past history is at the high end of the spectrum, particularly we're off roll for that long when it's occurred. So that gives the court concerns about your prospects for rehabilitation at this point. Of course, it's never too late for anybody, and I hope that you do move on from this given your age. And given the fact that really any future offenses are going to result in just higher guidelines and more prison time. As it is, I do think that a sentence at the low end of the guidelines here, which is 19 to 38 months, is appropriate given the nature of the crime here. And again, the fact that it's on the low end of the spectrum in terms of severity and is rooted, I think, pretty firmly in your substance use disorder. So I think all of those things balanced, the court finds that a reasonable and fair sentence within 21 months to 10 years in the Michigan Department of Corrections. You have credit for 45 days served. Crime victims assessment of $130, court costs attorney fees of $250, and $68 state costs. You have the ability to seek an appeal of this sentence, and Mr. Thompson is going to provide you with the papers that explain to you what your appellate rights are.
Thank you. So, Mr. Van Wormer, you keep these 2 copies. If you wish to file an appeal, you have to decide that right now. You fill this out and submit them with 14 days request an attorney on that.
Thank you, guys. Thanks, Mr. Johnson.
Mr. Van Wormer?
Mr. Thompson, did you have any other cases this morning?
I don't believe I have anything this morning.
Let's take a short recess. Our next hearing set for 10:15. Back on track. Versus Hellebuck, file number 255402.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Schuster, speaking on behalf of Ms. Hellebuck.
Right, records reflect Ms. Hellebuck present here in the courtroom today. This is a date and time set for sentencing in this matter. Ms. Hellebuck, did you have an adequate opportunity to go through the pre-sentence report? Talk to Mr. Trush about that.
Yes.
Okay. Mr. Trush, are there any additions, deletions, or corrections to the application?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Scope, if people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the court sat through this trial. Frankly, I tried to resolve this case in many ways, but Ms. Hellebuck has a difficult time taking responsibility for her actions. We'd be in a different position right now were that not the case. You know, she isn't doing particularly well right now. She has a pending retail fraud case. She had a no insurance when she crashed her car, but we pled that out through the retail fraud. She has a possession of meth case down in the Saginaw Chippewa case being handled in Isabella County. I don't know what happened to Ms. Hellebuck, but she is really struggling with where she is in her life. She has 8 prior misdemeanors and 2 prior felonies. And I think she needs to learn to take some accountability. So I think the recommendation is appropriate. I have nothing further to add.
Mr. Trush.
Your Honor, a few things that I do want to correct. I mean, the charge that she referenced in regards to methamphetamine, that's resolved and it was resolved with a misdemeanor. It's not a pending charge. And frankly, I mean, she resolved that while this was pending. So while I understand the prosecutor's position that there's 2 prior felonies, I think frankly, both of those are sort of in a weird position, one of which is a high court misdemeanor, again, which I do understand for some purposes a felony, for some purposes considered a misdemeanor. The other is an attempt felony, which was a 1-year offense, but still, again, I understand why it's there, but I do think it's an important distinction. I would agree with the prosecutor. I do think Ms. Hellebuck is struggling a little bit right now. I don't know if the PSI's recommendation is the best way to address her issues. I would identify to the court, again, I think the low end of the guidelines here is 0. I can certainly understand why they might recommend some upfront jail. I would remind the court this is a non-violent offense, and frankly, Ms. Hellebuck has non-violent history. This is the only, and again, this isn't really an offense of violence. I think the court viewed the video during the trial, has a clear view of what happened. It wasn't violent. It was non-compliance. She has no history of violence. She has a history with some property crimes and she has a history with some substances, which I think she would acknowledge to you. She has some issues she needs to address. She struggles with mental health and she's still working to get a grip on some of those issues. She's reported to me just recently, she's changed the doctor that she's treating with in an attempt to get a better grip on this. She struggles with that. And I think some of the mental health stuff, the mental health issues comes through in the PSI. She identifies things in the PSI that are really sort of negative and indicative of the mental health problems that she has. Identifying things like not having any sort of support structure. And I don't think that's accurate. She has consistently had people who have appeared with her and supported her in court. When I've spoken to her, I mean, she's identified. She recognizes now that she has support from her family and she has support from her community and church. But I think, you know, the difficult thing sort of with mental health and depression type things is we tell ourselves those people aren't there, right? We tell ourselves that it's a burden for us to lean on those supports. Contemporaneous with the arrest here, about a week later, she's admitted to the ER here in Grayling. I have records here where she is admitted suffering from mania and psychosis. And again, I've raised that to the court because mental health continues to be an issue. And again, frankly, I think in the video, you can see that. Some of the behaviors there aren't sort of what we would expect from normal behaviors from people. Contemporaneous with this, she was placed on new medication, Wellbutrin. And the side effects of that are consistent with what we're seeing. And it's consistent with what she was admitted to the ER a week later for. And again, I have the record for the court if the court wants to review it. But again, listed side effects for that drug include anxiety, irritability, false beliefs, extreme distrust of other people, agitation, delusions, hostility, mania, aggression, psychosis, delirium, and manic reactions. I think what we see there is consistent with that. I would suggest to the court, I think Ms. Hellebuck is a person who likely needs more support in the community, from community mental health, from her healthcare providers, and frankly even housing support. Following the recommendation here, I think frankly puts her in a position where she's going to have negative impact on employment, negative impact on housing. And I just don't think the circumstances here warrant that. I think it would be more appropriate to hold jail in abeyance, allow her to continue to work on her mental health. And she's either going to be successful in probation or not. But I don't think upfront jail is appropriate, given the guidelines, the nonviolent nature of the offense, the lack of any violent history. I think it's more appropriate to hold the jail in abeyance. Thank you.
All right, thank you. Ms. Hellebuck, anything you wanted to say? All right, I read through the report, so I'm familiar with all the information contained in that report, along with their circumstances and background. Of course, I sat through the trial, so I saw all the evidence that was presented. I watched the video. So I'm really well versed in the facts of what happened in this incident, as well as your past history. And your behavior during the incident is certainly concerning. Watching that video was difficult to watch from the standpoint of, if you're a law enforcement officer in that situation, we're a really difficult person to try and deal with. They were there to try to help you, and you were doing everything you possibly could to prevent them from helping you. And in fact, turning it into a situation where now you're the one who has to be restrained and eventually arrested. And so, your behavior through that turned that situation into what it was. And I think those officers showed a great deal of restraint and patience, much more than the average person would with you in the way that you were acting. So your behavior during that incident is concerning to me, even if it wasn't violent. Your behavior during the trial is concerning to me. It's very apparent to me watching you watch the officer's testimony that you were so indignant and seemed so offended by what the officers were doing. And the way that you looked at the officer while he was testifying, facial expressions, was very clear to me that you just don't get it. And even if I could say that you were. Ma'am?
I'm sorry, I thought I
Can you leave the courtroom until you get your phone taken care of?
Yes. I thought I had shut off, I'm sorry.
Even if we could say that you're having a bad mental health day during this incident, it doesn't excuse your behavior after that. You have plenty of time to come to your senses and be like, wow, yeah, I was really acting poorly there. I'm going to take responsibility for this. And just like Ms. Koch said, I mean, it didn't have to, just like the incident itself didn't have to be what it was. You don't have to be facing what you're facing right now. But for whatever reason, you felt like you were wronged in that situation. And to me, that is a very distorted view from everybody else's perspective. And it puts you in a position where the guidelines here are 0 to 21 months. I mean, I could be within the guidelines to send you to prison. I don't think that's appropriate in this case, but the should drive home to you the seriousness of your conduct and your past history. I do think probation is appropriate. I think a degree of supervision, an opportunity for you to get some resources available to you to deal with some of the issues that have been brought out today through sentencing by Mr. Trush is absolutely appropriate. I am going to make probation part of the sentence. I do think that jail needs to be part of the sentence too, because I think you need to face some consequences for your actions here. I think it's important for you to have this have a real impact on you. And I think jail time is necessary and appropriate to do that. So the court is going to sentence you to probation for a period of 2 years. The court's going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to sentence you to 90 days in the Crawford County Jail. That's at the low end of the guidelines. The court finds that it's an appropriate sentence to address your conduct both during the course of this incident and during the trial. You do have credit for 3 days served. The court will impose a crime victims assessment of $130, court costs $325, attorney fees of $350, $68 state cost, and supervision fee of $30 per month while you're on probation. You do have the ability to seek an appeal of this sentence, and Mr. True should be provided.
Your Honor, we went over them prior to coming into court. I've tendered to the clerk the acknowledged copy of the appellate rights.
All right, thank you. Sell about your remanded to the custody of the county. People versus Brian Schlapp, case number 235211.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, deputy attorney.
Mr. Schlapp, you're here today on a show cause that alleges that you violated a couple conditions of your probation. Are you aware of why you're here before the court today? Yes, sir. I want to go through your rights with you. You do have the right to have a hearing as to whether or not you did violate your probation. You have the right to have an attorney present at that hearing for any subsequent proceedings. If you can't afford an attorney, one will be appointed for you at public expense. Mr. Thompson's here today for purposes of this arraignment. And if at any time you need to consult or want to talk with him, I will take a break and allow you to do that, okay? If you are found guilty of either of the alleged violations, because this is a technical violation, Mr. McFeldez is fit, would this be 15 days?
15 for the first, 30 for the second.
Okay. Do you understand that?
Yes.
Okay. Have you had an opportunity to speak with Mr. Thompson about how you want to proceed? Yes, sir. Mr. Thompson.
That is correct, Your Honor. It's my understanding that Mr. Schlapp wishes to enter a guilty plea to technical violations. It's further my understanding that Mr. Schlapp will be requesting a PSI for sentencing. Mr. McFall has been recommended for the sentencing. We set out that Mr. Schlapp continues to do well with his probation, that his sentence would be a short extension of his probation, but that if there are further violations, Mr. McFall would be requesting jail time as the same.
Mr. McFeldez, is that correct?
That's correct, Judge. I've spoke to Mr. Schlapp and Mr. Thompson this morning. Spoke to Mr. Schlapp previous to this with his guilty plea. I just asked this to be set out a normal 30 days with the understanding my recommendation would be he's on a good track right now with this no drinking, and I would be recommending just a short extension because his discharge date's coming up in December. There's a violation between now and then, I would be recommending some jail.
Okay. All right. Mr. Schlapp, is that how you want to proceed today?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the signatures to help you out.
Sir.
Mr. Schlapp, you understand that by pleading guilty that you'd be giving up the right to have a hearing in this case?
Yes, sir.
And again, the maximum penalty is basically up to 50 days in jail.
Yes, sir.
30, Judge.
Or I'm
Sorry.
sorry, 30 days, just a year, 2 year. With that in mind, how do you want to plead for the violations?
I have to go through the day, sir.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've all said here in court?
No.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you did violate probation?
Yes, sir.
So this alleges that, well, let's back in, on August 11th and September 2nd of 2025, both of those days, were you on probation here in Crawford County?
Yes, sir.
And at both of those times, were you aware that one of the conditions of your probation was that you were to not consume any alcoholic beverages?
Yes, sir.
And on both of those dates, did you consume alcohol?
Yes.
The court finds that your plea is knowing, voluntary, accurate. The court is satisfied. There's a factual basis to support a finding that you are guilty of both violations. The court will accept your guilty plea as full. As we've all indicated here, we'll send this for a hearing 30 days. We provide the date and time of that hearing. Did you wish to request an attorney to represent you at that next hearing?
No.
Okay. If at any time you decide you do want to have that, you contact the court or Mr. Thompson's office and request to make sure that that is taken. And then at that hearing, anytime you wish to have an attorney, you have the right. Mr. McDowell, anything further on this case?
No, Judge.
Nothing further for today's record. Thank you.
Thank you, Mr. Schlapp. That's all. People versus Kurt Richard, case number 255461.
Sierra Coke on behalf of the people.
Mr. Pritchard, you can write at the podium here, please. Record should reflect Mr. Pritchard's presence in the court.
Mr. Pritchard.
Mr. Daniel, can you tell me the status?
Your Honor, we're still working on resolving the case. I believe we're going to resolve it, but as I said, it's for another hearing prior to a trial. I think that issue will be resolved, this hearing.
Are there,
No discovery concerns. I have the evidence of currently Mr. Pritchard going through counseling and just wanted to get some additional counseling under his belt before we proceed.
Okay, let's go.
Your Honor, we would just ask for a 30-day adjournment, set this for a final status conference and determine whether or not it's going to go to trial. We have kind of limited trial days, so if we're not going to go to trial, I don't want to set it for trial. I think I've spoke to Mr. Daniel several times. I think we are going to resolve it. So if we could just set it out 30 days, we can have that determination then.
Mr. Daniel, is there anything that's going to require more than 30 days?
I don't believe so, Your Honor, no.
Okay.
Starting intended vacation starting tomorrow, but I'll be back in 30 days.
Okay. All right, so Mr. Pritchard, I'm going to set this for a hearing in about 30 days. At that hearing, I'll be asking whether you want to enter into a plea agreement or not. Whatever decision you make on that day will be final.
Okay.
So I'll need you to make sure that you talk to Mr. Daniel and that you're prepared with a final decision on that day. All right.
Thank you, Your Honor.
Thank you. That's all for today.
Thank you.
For the Johnson sentencing.
Sir, are you Mr. Baker?
Yes.
Okay. If you'd like to come forward, please. The court will call People versus Benjamin Baker. This is file number 255439.
Sierra Coke on behalf of the people.
Good morning, Your Honor. James Dick on behalf of Mr. Baker, standing to my right.
And Dick, will you tell me the status of this file?
Yes, Your Honor, we do have a resolution in the works here. We just need to allow the other case to catch up from the district court. It is currently scheduled for a preliminary exam on the 21st of October, and it will be waived so that we can work out the resolution here. Okay, we just ask for a brief adjournment.
If, so we would need to set both files for a hearing in November, is that what you're?
Yes, I think we need to get him to waive up because we're gonna do a plea agreement, but because of the way one's gonna be non-public and one's gonna be public, we have to get them up on the same day.
Okay, so Ms. Cook, obviously you don't have an objection.
No, that makes the most sense procedurally.
So I'm gonna order that new file be assigned to me and then that be set for hearing at the same time as this file in about 30 days.
Okay. And Your Honor, I was going to ask if I could address one item of bond.
Yeah, 1 second.
Sure.
Hmm. Yeah.
Okay. Yeah.
Yeah. let's use that.
Is that on this file or the other file?
Oh, you know, it is. Never mind. Yeah, that is the other one.
Just send it over to me this afternoon and I'll look at it.
Okay, and so bond issue.
My mistake. It was on the other file.
All right, apologies. Okay, Mr. Baker, do you have any questions about how we're gonna proceed with your?
Very well.
Okay, thank you, that's all.
Thank you.
Okay.
Mr. Dick, were you ready with Ms. Henning's case?
I will be in just a couple minutes, Your Honor. Okay.
Okay. Mr. Vernon, did you have anybody that we can take at this time?
No, I have not. Mr. Woods is on his way, but I haven't spoken to him yet. Unless Mr. Cutler is on Zoom.
Not yet.
Okay.
Let's take a short recess and come back on the record. We're on the record in People versus Amber Henning. This is file number 255443. The record should reflect Ms. Henning's present here in the courtroom today. Mr. Dick, can you tell me the status of this file here today?
Yes, Your Honor. We are requesting to set this for a plea hearing approximately 30 days out. We have one portion of the plea deal in the works still. So it will be able to have everything ready to go by the next court date.
Let's go.
Your Honor, she is trying to get into a rehabilitation program, and there's some things she needs to do before she can finish that. I think it's appropriate to set it out in 30 days.
Henning, have you had an opportunity to speak to your attorney about this?
Yes, I have.
Is that how you want to proceed as well? We'll set this for a status conference, plea hearing in about 30 days. Ms. Henning, at that hearing, I'm going to be asking you for a final decision about any plea offers in this case. So between now and then, make sure you talk to Mr. Dick, make sure that you're aware of all the consequences of whatever your decision is, and that you're ready for the final decision on that day. Okay.
I know you are. Thank you.
Thank you.
Yeah.
Mr. Byrne, I think Mr. Cutler is, doesn't show his name, but I'm assuming.
It appears to me that both of my clients, Mr. Woods and Mr. Cutler, will be appearing by Zoom, so I don't. Whichever one it is.
Okay.
I will be ready to go.
That's good.
I believe we sent a request over from Mr. Woods to appear by Zoom.
Yes. All right, sir, can you unmute, please? There we go. Can you tell me your name, please? Can you say that again?
Dennis Woods.
Mr. Woods, okay. All right, we're on the record in People versus Dennis Woods, and this is file number 235201. The record should reflect Mr. Woods is appearing today by video by prior approval of the court. And Mr. Vernon, can you tell me how we're going to proceed in this file?
So, Your Honor, we're going to be asking for a short adjournment. We'll be asking for your next scheduled motion, half day, whatever is available. After Mr. Woods posted bond, our communication has dwindled a little bit, so I want to make sure I have good communication with him before we make any decisions.
Your Honor, I'd ask, I mean, the court can adjourn it if the court wants to do it. We adjourned it 2 weeks at defendant's request on 9/15. And it's not for lack of trying on the defense counsel. It seems to be the defendant. The plea offer in this case was made in July of 2023. He absconded for 2 years on an FTA bench warrant that was issued on 11/20/23. So I understand that we can adjourn it, but I would ask that to be the cutoff date and then to set it for a trial. This has been going on far too long.
Okay, so Mr. Woods, we're going to set this for one more hearing. It's important that you stay in touch with your attorney, Mr. Vernon. At that next hearing, I'm going to be asking you for a final decision about whether or not you want to accept any plea offers or whether you want to go to trial. Okay, do you understand that? You say that again, I'm not hearing your voice. Yeah, your voice isn't, you need to get closer to your microphone on whatever device you're using.
Yeah.
All right. So you'll be provided notice of the date and time of that hearing, and given the problems with communication here, Mr. Vernon, I'm unlikely to allow Mr. Woods to appear remotely next time. I think what we're seeing here would be very difficult to take a plea if that's what we're going to do.
Okay.
So
we won't make that request.
All right. Mr. Woods, do you have any questions at all?
I mean, other than mock Zoom hearings, because I live 4 hours away.
Yeah, well, your case is here in Crawford County, so this is where things are gonna happen with this.
I can't have it on Zoom, is what I'm asking.
Not based on the way this conversation's going here. If you have a better device or something, but I'm having difficulty hearing you, and it's gonna be very difficult to proceed with your case with this method of communication.
I can easily just get another computer. I didn't know you wouldn't be able to hear me on my phone.
Well, I didn't know that either. That's part of the problem with technology. So next time, we're just gonna have you appear here in court, okay? That way I can make sure I can hear you. So, all right, that's how we'll go forward. Mr. Woods, you're free to disconnect at this time.
Thank you, Your Honor.
Are you Mr. Johnson? Yes. Okay. Mr. Barberry, are you ready with that file? Yes. Okay. Court will call People versus Joshua Johnson. Is file number 255440 and 255464. The record should reflect that Mr. Johnson is present here in courtroom today.
You're Coke on behalf of the people, and we do have a victim here that would like to speak.
Morning, Your Honor, Dave Barber, on behalf of Mr. Johnson, standing to my right.
Okay. And Mr. Johnson, have you had an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, sir.
Counsel, are there any additions, deletions, or corrections to the body of the report?
Just a couple of corrections, Your Honor. On page 1, under the plea agreement, it indicates docket number 2025-5454. It should be 5464.
Is Coke in objection to that change?
No.
Five of the CJF 285, sorry, 284. Defendant's description of offense. Line 2, it indicates that his ex-wife had cancer, and that should read, but my ex-wife had canceled.
That's that.
No, Your Honor.
Okay.
And what?
Then, page 10, under substance abuse treatment for the CFJ 284, indicates the start date of 9/22/25. I'm not sure exactly what the start date was, but I know it would have been back in the client wasn't aware either, not September.
No.
Other additions to the
No, Your Honor.
Are there any challenges to the scoring guidelines?
None from the defense, Your Honor.
No, Your Honor.
Hope you have any other changes to the PSI?
No, Your Honor.
You indicated that you don't have any challenges to the scoring.
No challenges to the scoring.
All right. I did receive a written victim impact statement. I did have a chance to review that. That was with Madison. So I did read that prior to the hearing today. And so Ms. Polk, any victims that wish to address the board?
Madison would like to add a little bit more. She indicated, and she is present.
Mr. Carver, you and your client can see that in the court paperwork. Ma'am, can you come right up to the podium for me? And your Madison Gentilla, can you spell your last name? for the record?
JUNTTILA.
What is it that you'd like to say?
I just want Josh to know that me and his mom and everyone cared very deeply for him, and we very much wish that he would get sober for him and his kids, and so that he can have the life that I know he wants and deserves, and that everyone wants him to have and deserve. And so that's all I'd like to say.
And I think that what Madison said is very much in line with the letters that I read that we just got today. It's pretty consistent, and in this job, I see this a lot. People who are nice people and generally hardworking, you know, his neighbor likes him, that kind of thing. And then they start drinking and they turn into people that people just don't like and end up in these violent situations. They're operating vehicles. It's like, once you start drinking alcohol, all the decisions you make in your life are bad and you become a person that people don't like. Mr. Johnson doesn't have a very big criminal history. He only has 2 prior misdemeanors, no juvenile record, no felonies. His guidelines are low because of that, but you see a history of domestic violence. And, you know, I could only assume that this has been an ongoing problem for Mr. Johnson his whole life. Some people can drink and some people cannot drink in moderation. He is one of those people that cannot. So I hope that this is a wake-up call to him. You know, when you only have 2 prior misdemeanors, you haven't been in the system a lot, and the recommendation is 6 months in jail, which is a long time. But I hope that he takes whatever time the court gives him and reflects on that, and that I don't continue to see him and hear his name and have him come up with police reports repeatedly. So I'd ask the court to follow the recommendation. Thank you.
All right, thank you, Mr. Beverly. If you and your client would like to come back to the podium. Anything that you'd like to say on your client's behalf?
Thank you, Your Honor. Your Honor, I think the prosecutor made an excellent point. There are some people that can consume alcohol, and there are some people that cannot. Clearly, Mr. Johnson is represented as though he obviously cannot. I think he now, maybe more so than ever before, understands the position that he's in. When you look at his family history, certainly there is a history of substance abuse in his family. Mr. Johnson lost his father to cirrhosis of the liver. I think that loss played a dramatic role in his turning more towards alcohol in many ways to treat some of the issues that he's experienced in his life, including his father. Your Honor, Mr. Johnson obviously did something he should not have done here. He's taken full responsibility for that. Throughout the course of getting to know Josh, throughout my representation, I know him to be a very kind, gentle, decent human being. Not the person that we read about in his police reports. He presents obviously as though he's got a drinking problem, but he also has an issue with being violent when he drinks. Those are 2 things that you can't have in combination. I think the recommendation in this case of 6 months on one file and 8 months on the other is fair. However, I would ask the court to consider the 6 months on both files in light of the fact that he was lodged for 112 days, did not receive credit on the other file until his bond was revoked at the hearing. Your Honor, I know that Josh also wants to address to the court. Before that, I think it's important to note that both the victim and his mother are present in the courtroom today. He does have the support of his family. He has 2 sisters that don't have any substance abuse issues. And I think Josh is at a point in his life where he realizes he's at a fork in the road. He wants to get help for his substance abuse and addiction. I know that his record recently, the fact that he went into rehab, left after 2 weeks, does not bode well for him. But he does indicate that he wants to have another opportunity to go to rehab. If the court's inclined to go with the 8-month recommendation, I would ask that he have an opportunity to be released from rehab. If he does need some medication, he's got a long road to recovery. He's gonna, based on both his family history and his criminal history, and in our discussions, he understands that he's gonna battle this addiction for the rest of his life. And he recognizes that he's gonna have a long road to go. And jail is the first part of that road. So with that in mind, Your Honor, I'm going to turn it over to Mr. Johnson, but I would ask the court to follow the recommendations on the 6 months as opposed to the 8 months. Excuse.
Thank you. Mr. Johnson, maybe you would say that.
Yes, Your Honor. I feel very ashamed for what I've done. There are no words that justify as to how terrible I feel about what I did. I take full responsibility and there's no excuses. My top priority moving forward is to take every avenue I can to never touch alcohol again and focus on my anger issues. I ask for your mercy in sentencing because I have 2 young sons waiting for me to be back in their lives, and I'm fully committed to living a law-abiding, productive life.
I did read through the report, so I'm familiar with the incidents that bring you here today. I'm also familiar with your background in your circumstances. Based on the report. Take all of that into consideration. Of course, Mr. Gentile, what you've had to say here today, appreciate your statements, your point of view on this. Not only what you have to say in court, but your letter. That's something that's I could read. Gives me a little bit different look into a more personal view of the case as opposed to the information that I get through the report. So thank you for that. And so, yeah, I mean, there's a number of things that stick out to me about this case. Number one, that the nature of the incident is concerning. And I agree with what Councilor yourself have said, that there are people that use alcohol and it's not a problem. There are people that one drop is just too much. And you know, alcohol has the effect of, it causes disinhibition. In other words, when you're sober, you can stop yourself from doing certain things. When you're drunk, or even had a little bit of alcohol, maybe in your case, that self-control goes away, and you do things that you're normally able to stop yourself from happening. I'm glad to hear that you are looking at anger management counseling as well, because again, I don't think it's just alcohol. Alcohol is what removes that barrier, and then those underlying things come out. And so you need to deal with those underlying things in addition to the alcohol, because those aren't going to go away just because you stop drinking. Those are going to stay there, and they can come out again. So I do think it's something that you need to look at from both of those perspectives, and I'm glad to hear you say that. And I think that gives the court some cause to be confident that you can do well on probation, that you've identified what your problems are, and that you can take corrective action. And I also think, based on just what I've seen here, you probably have a lot of support that can help you with that. It's important that you lean on those people if they're willing to help you and listen to what they have to say, and pay attention when they tell you that you're going in the wrong direction, because they have your best interest in heart, whether or not you can see it. So it's good to trust in those people. As I said, though, I think, you know, there needs to be a degree of punishment here, not just for you, so that you understand that this is not acceptable behavior under any circumstances, for the deterrent effect, so that you know that if you do engage in this again, there's going to be more jail time waiting for you, and so people in the community see that this is not, as a society, we can tolerate. That is going to be met with punishment and with consequence. I think it also should be an indicator to you in terms of your probation. Now that you've identified this as a problem, you're going to have an opportunity to deal with it. But if you don't, and you violate your probation, it's going to be more jail time after that, because it won't be an excuse anymore that I didn't know how I was going to react. We all know how you're going to react if you're using alcohol. So any future incidents, you really have to have a good excuse for those, other than you just don't want to take care of the problem. So all of that being said, I think the recommendations are well crafted. I think they're fair. I think they provide for rehabilitation, but also address, as I indicated, the seriousness of your conduct and the need for a consequence. So I'm going to follow the recommendations. That's the file number 5440. Probation for a period of 24 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in that report, including that you served 8 months in the Crawford County Jail with credit for 90 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state costs, provision fee while you're on probation of $30 per month. As to file number 5464. Probation for a period of 2 years, 6 months in the Crawford County Jail with credit for 113 days served. On that file, a crime victims assessment of $130 and $68 state cost. That's as to the domestic violence charge. operating while intoxicated, 93 days, with credit for 93 days served, $50 state cost. All of those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence. Mr. Gregory, if you provided those appellate rights. I have not. So they should be on the table right there. If you can have him acknowledge receipt of the appropriate copies.
Mr. Johnson, did you indicate appellate rights? Yes. Your Honor, my client has received appellate rights and is signed to proceed as same.
Thank you. Good luck to you going forward, Mr. Johnson.
Thank you, Your Honor.
There at the Charlevoix County Jail, we're going to need you to unmute on your end. I don't know if you need a corrections officer to help you with that. Okay, are you able to hear me there? Are you Mr. Cutler?
Yes, sir.
Okay. All right, we'll go on the record and people. Cutler, this is file number 214917. The record should reflect that Mr. Cutler is appearing today from Charlevoix County Jail. And this is the date and time for sentencing in this matter. Mr. Burden, did you have a chance to go through that?
I did, Your Honor. I met with Mr. Cutler separately yesterday or the day before. We are prepared and ready to proceed.
All right, Mr. Cutler, did you have an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, sir.
Discuss that. Yep. Okay. Mr. Vernon, are there any additions, deletions, or corrections?
So there is one correction. I don't think there's an objection to it. On the, what would be page 2, it identifies that Mr. Cutler pled guilty to an added count 4 domestic violence and or assault against a pregnant individual as a second offense. It's not a second offense, it's a first, which was consistent with 2 sentences down where it says it should be deferred under 7694A. Obviously wouldn't be a possibility.
Any objection to that change?
No, he is correct.
Other than that, we have no additions, corrections, or challenges. There wouldn't be any, but, and we would ask the court to follow the recommendation.
Thank you. Ms. Koch, do you have any additions, deletions, or corrections?
No, Your Honor.
Do you have any victims that wish to address the court on this case?
Her mail was returned, and the phone number is no longer working. We have not had contact with her.
All right. Anything on behalf of the people for allocution today?
Yeah, I think the recommendation is appropriate. You know, he's in jail for something different. This is an old case. I just asked the court to follow the recommendation. Thank you.
Mr. Vernon.
Here, the recommendation is for 90 days with credit for the 90 days. We would ask that the court follow that recommendation. I talked to probation about this. He is now a resident up in Charlevoix County. We're going to be asking the court to transfer jurisdiction or supervision up there once he's released from their jail.
Mr. Cutler, was there anything you wanted to say today?
No, sir.
All right, Mr. Cutler, I did review the report, so I'm familiar with what happened in the circumstance and what brings you before the court here today. And also your background, a little bit of the background that was provided as part of the pre-sentence report. And looking at the circumstances as a whole here, the court is generally going to follow the recommendation outside of probation. I don't think that probation is appropriate in this case, given the nature of the circumstances, the age of the case, your previous terms on probation. Looking at the report, it looks like you've been on probation a number of times in the past, and And so I don't view that as something that's warranted in this case. And was this part of the plea agreement?
What's that? Yes.
I didn't think it was.
Well, it says no objection to 7694 if eligible.
Okay. But that wasn't part of it, part of this agreement.
No, I wouldn't say it was binding, so I think there was a no objection to.
Offer the added count for DB 76948 if eligible, no objection to it, but not part of plea.
Okay, all right. So again, based on your previous terms of probation, Mr. Cutler, again, I don't find that that's something that's warranted in this case. So the court is going to sentence you to straight jail. I do think that the jail sentence that's recommended of 90 days with 90 days credit is appropriate. I think it's an adequate punishment for the crime in this case, given the nature of the circumstances. I don't think additional jail time is warranted. So the court is not going to sentence you to any additional jail time. So again, the court is going to sentence you to 90 days in the Crawford County Jail. You will have credit for 90 days served. The court is going to order, however, that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $50 state cost. You do have the ability to seek an appeal of this sentence. Because this is a misdemeanor, there are no written appellate rights, but if you did want to file an appeal in this case, you would need to do that within the next 21 days. If you had questions about that, Mr. Vernon, your attorney, would be able to help you answer any questions about the appellate process. Have any questions at all, Mr. Cutler?
No, sir. I just want to say thank you and I appreciate the court's time.
All right, Mr. Vernon, anything further on this file?
Based on that last statement, is the court going to continue my representation of Mr. Cutler until the appellate period would expire?
Yeah, only within the next 21 days.
Thank you.
Just two housekeeping things. Also, is this being, is he on a deferral or no? No, okay.
No probation.
Second is there's still a outstanding bench warrant that was not recalled until he was sentenced to want to.
For this file?
Correct.
Okay.
To sign that.
All right. Mr. Cutler, just so you're aware, there was a still an outstanding bench warrant. I think we ended up scheduling this case because you sent a letter to the court.
Yes, sir.
So I'm signing an order recalling that bench warrant, so that won't be active anymore, just so you're aware.
Thank you so much.
Okay, that's all for today, Mr. Cutler. We're going to disconnect at this time.
Thank you, guys. Have a good one.
Sure.
Bruce, we're ready on Mr. Lovely's case. Yes, Your Honor. Mr. Lovely, if you want to come forward, please. We'll go on the record in People versus Michael Lovely. This is number 225137, 245341, and 254444. The record should reflect Mr. Lovely's presence here in the courtroom today. This is the date and time for sentencing on the new file as well as the probation violations. Mr. Lovely, do you have an adequate opportunity to go through all these reports?
Yes, sir, I did.
Okay. Are there any additions, deletions, or corrections to any of the reports?
No, Your Honor.
Are there any challenges to the scoring of the guidelines which file 255444?
No.
So do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of people for Ellen?
Your Honor, for most of my career here in Crawford County, I've dealt with Mr. Lovely, so I feel like I know him fairly well. He makes a lot of bad life choices, but overall is a very nice person. He makes choices to hang out with people who drag him into these situations, and he continues to make those poor choices. His guidelines are high, and he's starting to rack up a pretty solid criminal record with 2 felonies and 3 misdemeanors. He's only 38. I think the recommendation is appropriate. I think we're going to keep seeing Mr. Lovely until he decides he's too old and too tired to continue down this path. You know, he has a family that supports him. They continue to support him. I have run into them in public, and they have went on to tell me how much they support him. You know, he has kids that need him. I hope that he makes better choices going forward. I'd ask the court to follow the recommendation.
Thank you, Your Honor. I actually agree with the general sentiment the prosecutor said. My experiences with Mr. Lovely has been, he is a pleasant person to deal with, and he's a likable guy. I think what we see here is, you know, a trajectory that we see from time to time. It's somebody who gets involved with substances, and, you know, oftentimes when they get involved, they can manage things. And as things progress over time, it becomes more and more difficult for them to manage them. They find themselves in court more often. And again, it gets harder to sort of be that normal functioning person. And I think that's where Mr. Lovely is. And from talking to him quite a bit in preparation for the hearing here, I think he, as the prosecutor would put it, I mean, he's too old and he's tired of doing it. He wants to make changes. I know he has been in contact with Memory and has made arrangements to try to get a bed available for himself. I think they're still in the process of looking for it. One facility had accepted him, but now they don't have a bed. He's looking at a different facility. But generally, I think, you know, the recommendation here, both on the probation violations and on the underlying case, I think it's fair and reasonable, consistent with what the guidelines range would be. I would suggest to the court, given the amount of credit that he already has, I think almost 5 months credit that he's sitting on right now, I think it is appropriate to start to think about the rehabilitative side of the sentence. I would ask the court either now or at some point during the sentence to allow him to take advantage of the bed in a rehab facility if he can get that arranged. I tend to think with rehab, kind of striking while the iron is hot is important. He is motivated right now to do it. And he has expressed to me that even if the court did not allow him to do this when he completes his sentence, it's still his intention to go in and to go into a rehab. I think he recognizes he needs to do it. I think as part of a sentence, it gives him more incentive. And I think that because we all know how life can get in the way. If he waits till the end of the sentence to do it and he's released and he's kind of doing it on his own, we know what the data says. And the data says that when there's court involvement, the number of people who actually go and complete is higher than those who do it on their own. And I think it's a difficult thing to do, to put your life on pause for, 30, 60, 90 days, even if it's ultimately what's better for you in the long run. But again, I think from my discussions with him, he is very motivated to do it right now. There's been a substantial portion of this that has been, punishment already. It would seem to me that we'd be in a good position, I think, to allow him to avail himself of a rehab setting. And then I think the added benefit is we have additional jail potentially in abeyance that can be doled out while he's continuing to be monitored. Thank you.
All right, thank you. Mr. Lovely, anything that you wanted to say?
Yeah, that he's in Sierra, I'm getting too old and I have too many people who love and depend on me, and I'm, you're a nice guy and everything, but I'm tired of coming in front of you and, I just, I owe it to have myself and to everybody where I need to be the person I know I can be, and if you give me that opportunity to seek the help, why I'm smart enough to get it right now, I would greatly appreciate it, sir.
Okay, I read through all the reports, familiar with the circumstances of this case, I presided over Ms. Bublitz's case, so I kind of already knew about that whole course of events there. And then obviously your probation cases I was aware of. And yeah, I mean, you seem like a nice guy. You seem like outside of this, probably wouldn't have much issues. So I can certainly accept that this is your biggest problem, biggest hurdle in terms of being able to live a successful life that you're happy in. Frankly, the rest of the community would like to see. So yeah, I mean, I think that's a fair recommendation. I'm going to impose the jail time. I'm going to discharge you unsuccessfully from the probation. I don't think there's any point in continuing those cases at this point. If you're able to get into an inpatient facility, then I think you served enough upfront jail time here on this case. Given the underlying circumstances that going to hold the rest of that time in advance. If you're not successful in treatment or you leave, come back to jail and serve the rest of your sentence. If you are successful, then you wouldn't have to serve the rest of that jail. I don't know, at this point, how much of a motivation that's going to be for you. I tend to think, I'm not sure, what the data is, but I tend to think that the people that are successful, from what I see, are people who want to do it because they're just tired of living this life, not because the court is forcing them to do it. Everybody's motivated to do it when the only other opportunity is to sit in jail.
Yeah.
The real motivation has to come from inside, and the real desire to not do this anymore has to come from inside. I'm going to give you the opportunity to do that. If you don't, you'll come back, you'll do the jail time, and you'll want to do it. But if you do decide to take this opportunity, I hope that you're successful. So the sentence of the court, for the record, on file number 255444 is going to be 10 months in the Crawford County Jail with credit for 142 days served. The court will, if you're able to get into an inpatient facility, the court would allow you to be released to treatment and hold that time in advance. If treatment is successfully completed, if treatment is not successful, then you would have to return to jail and you would not get credit for any of the time that you were in treatment. Otherwise, you'll get credit for all the time in treatment and the remainder of the sentence held in advance. On that file, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost. As to the probation violation files 5137 and 5341, the court is going to sentence you on 5137 for 243 days in the Crawford County Jail with credit for 243 days served. On 5341, 217 days credit. 217 days with credit for 217 days served. Unsuccessful discharge as to both of those files and any outstanding fines and costs reserved. Everything for the record on the sentences. You do have the ability to seek an appeal of each of these sentences. Once you're sure you're able to address those appellate rights.
I have no reason to appeal. You guys have been amazing for me. Thank y'all.
Your Honor, just one housekeeping matter. Does the court, in regards to the rehab aspect of this, want me to prepare the addendum that we generally have prepared?
Yes.
Take care.
Thank you.
Go to rehab. Stop being bad.
Sorry.
I love you.
You guys, you got your minutes. Yes, I can second.
All right, sir, can you tell me your name there, please?
Dean Godding.
Okay. You ready?
Your Honor, so just to give the court a little bit of background,
Well, let me call her. Are we ready on that?
I would like to give you a little bit of time to talk to him, I think.
You would, okay, but we can call the case.
It can't be much time, because they only give you 30 minutes. The federal prison will shut them off. So,
All right, we're on the record in People versus Gadding, file number 255427. Mr. Gadding's appearing today by Zoom from federal incarceration, I believe, and so Mr. Church, you'd like to break out room?
Yeah, I mean, if the court either wants to clear the courtroom or I can walk out and go into a breakout room.
Clearing the courtroom is not going to guarantee you're going to have a confidential conversation.
Understood.
So, Mr. Gadding, your attorney's gonna sign in, and then I'm gonna put the two of you into a breakout room so that you can have a private discussion before we proceed, okay?
Okay.
we did get a notice that they only allow 30 minutes and then they'll cut it off and we could bring them here in person from Pennsylvania. So we'd ask that it be less than 30 minutes.
Okay, Mr. Church, you can be as quick as possible.
Understood.
I don't think the underlying here, take that one. Okay, Mr. Church, I'm gonna put you into that breakout room right now. Just waiting for Mr. Gotti to come back in here. I don't know why it's taking so long.
I think it usually takes about a minute after our breakout room is closed.
Okay, Mr. Godding, are you able to hear me again?
Yes, I am, sir.
Okay, we'll go back on the record in that file. Mr. Truce, did you have an adequate opportunity to speak to your client?
Yes, Your Honor.
Mr. Godding, did you have an opportunity to go through the pre-sentence report and talk to Mr. Truce about that?
Yes, I have, Your Honor.
Mr. Truce, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, are there any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
You know, Mr. Godding presents as 44 years old. He's now in federal prison. I don't know the length of his sentence. I'm sure defense counsel can enlighten us. The guidelines are 7 to 28 months. He has 24 prior misdemeanors and 15 prior felonies. Sometimes when I see numbers like that, I think to myself, how do you even have time to commit that many crimes when you're in and out of prison your whole life? I think he knows the drill by now, and I think the recommendation is appropriate, given his current circumstances. Thank you.
Thank you, Mr. Truce.
Your Honor, I just wanted to confirm, I think my office submitted 4 letters. Did you receive those?
Yes, I did. I should have said that before. I did receive all those letters, and I did have a chance to read all of them prior to the hearing today.
Thank you, Your Honor. The circumstances here, Your Honor, and I'm going to talk a little bit while I have the soapbox, so to speak, about sort of some MDOC policies and my views on those. You know, this is a circumstance, I think, where habit plays a big role in what occurred here. You know, habits can be very helpful when our brain is sort of put on autopilot and, you know, we essentially automate some tasks. I think, though, this is a circumstance where, you know, Mr. Godding has had some bad habits sort of automated into his brain. And he's in a circumstance where he was out in MDOC housing. I think he was being housed on the federal charges that he's in prison for now. And frankly, as he's there, he's very active in his church, and he's trying. I mean, he's making a big effort to make changes in his life. Unfortunately, the MDOC housing, frankly, their own housing violates many of their own conditions and rules. So, for example, they tell them, you know, you can't reside with felons. Well, the entire MDOC housing facility is full of other people who are felons. They place people next to, and you know, in a hotel with, you know, 24 other people who are all struggling to deal with the exact same, you know, substances and demons, so to speak, that they are. And I say all that because it's a tall task. I think it is a really tall task for people in that situation to avoid temptation. I, from time to time, have clients who they and their significant other are trying to get sober together. And I've long believed that when something like that happens, it can have a positive impact. You can be a support for each other, but I also tend to think that it kind of doubles your chance of relapse, because we know if one person relapses, the other's probably going to relapse too. And I think that's a circumstance that we see here. Mr. Godding, frankly, invited someone into his home who was struggling. They were someone who was homeless and living in a tent. The weather was not good, and he made that choice, I think, from the right place, trying to be helpful. That person brought substances into his house and sort of created this situation. And I say all that because, again, I think what happens there is, you know, Mr. Godding falls back into habits that he shouldn't. He falls back into the habits that he's trying to change. So I say all that because I really do, I do have concerns that these types of situations, we sometimes set people up to not be as successful as we could. And I think that's some of what's going on here. The person who was invited into his home, I think, was actually kicked out of the MDOC housing and was essentially living in a tent, behind the MDOC housing. Was not a good situation. With that in mind, I think the recommendation here is entirely appropriate given his current circumstances. He is sitting on a federal sentence that we expect, I think, to last about a year. After the year, he will be eligible to go into a halfway house, at least potentially. So I think the recommendation here makes sense through the lens of his personal circumstances. So I would ask the court to follow it.
Thank you. Mr. Gadding, anything you wanted to say today?
Yes, Your Honor. I think Mr. Truitt is right on point, and I would just like to say that I did come to Grayling for a new start. I'm not gonna let this trip me up. I take full responsibility for what I did. I let that person into my house. I did what I did. I'm sorry for that. I promise you this is not going to happen again. I've made a very substantial effort to change, and I'm not going, I thought I had basically played those tapes through. This was one that I didn't see it coming from this angle. There's more details we don't need to get into. She was involved in my church as well, and I thought I was helping from a good spot. But at the end of the day, I did what I did. So I'm sorry, and you won't see me in your court again, sir.
All right, thank you. I did read through the pre-sentence report. I'm familiar with the circumstances that bring you before the court here today. Like I said, I did read the letters that were written in support of you, Mr. Gadding. And based on those letters, I can certainly accept that you are trying to make a change, and that you're relying on your church community to do that, and that's great. If that's a source of support for you, then I think that's a positive thing, and I hope that you continue to do that, because somebody in your position, I think, needs all the support that they can get from people who are not engaging in legal activity or that are going to get you involved in more trouble yourself. I think you've acknowledged this. It certainly is apparent to me that regardless of the circumstances or MDOC policy or resources or anything else, it all comes down to your own decisions and your own judgments. And clearly this was not a good decision and not a good judgment. And certainly it's no secret to you how Department of Correction operates in the situation that you would be in. It's not like it was unexpected or a surprise that you would be placed in that kind of circumstance. And I think you have to be extra vigilant under those circumstances and avoid having any more contact than you need to have, and certainly not opening yourself up kind of intentionally or voluntarily to things that are going to lead you down the wrong path. But regardless of all of that, again, I think there are indications that you are trying to make a change, and I hope that you follow through with that. I think the sentence recommendation is appropriate given all of your other circumstances and the nature of this crime. So the court is going to follow that recommendation and sentence you to 7 months in the Crawford County Jail. You do have credit for 61 days served. The court is going to also impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. That sentence to be served concurrently with any other sentence you're currently serving. You do have the ability to seek an appeal of this sentence. If you haven't already received them, you will be provided with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Ms. Koch, anything further we need to address today?
No, Your Honor.
I would just indicate we did send the appellate rights over. They moved him out of the facility. They didn't tell us We literally scheduled a phone call with him, got into the phone call, and that's when they told us he was no longer there.
Okay.
So I don't think he's received them yet from me, but I'll get them to the facility he's at now.
Okay, and either way, the time limit. Mr. Gotti, good luck to you. That's all we have for today, and the court's going to disconnect at this time.
Thank you.